We are currently standing on the precipice of the most volatile shift in American firearms jurisprudence since 1791, and almost nobody is discussing the tactical reality of what comes next. The mainstream media is intentionally suppressing this information because they understand that knowledge is the precursor to resistance. We are looking at a 2026 crisis point of convergence of legislative desperation and judicial absolutism that will determine whether the Second Amendment survives as a tangible right or degrades into a historical footnote. The federal courts, in a move that has sent shockwaves through the Department of Justice, have not just tweaked the rules, they have fundamentally dismantled the operating system of gun control in the United States. However, do not mistake this legal victory for a permanent ceasefire. The state apparatus does not surrender power willingly. It merely retreats to regroup. The rulings we are about to dissect act as a temporary shield, a legal fortification that you must understand immediately. If you are operating under the assumptions of 2023, you are already legally vulnerable. The government relies on your ignorance of these new protections to continue their enforcement campaigns through intimidation rather than legal authority. We are seeing a complete inversion of the power dynamic between the citizen and the state, but this power is useless if you do not know how to wield it. This is not legal advice, this is a survival briefing for the modern American gun owner. The stakes have transcended simple ownership and have entered the realm of systemic preservation. What follows is a brutal, unvarnished analysis of the 10 massive changes that have just taken effect. These are the uncomfortable truths that the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, and state legislatures are desperate to keep buried in the dense text of court opinions. We are going to exhume them, dissect them, and arm you with the intellectual ammunition required to survive the coming years. Number 1. The historical tradition. Superstandard. We must begin by dissecting the absolute bedrock of this legal revolution, often mislabeled by casual observers as merely strict scrutiny, when in reality, it is something far more profound and devastating to the gun control agenda. The federal courts have moved beyond the interest-balancing tests of the past, where judges would weigh your rights against the government's desire for public safety, and have established the text, history, and tradition standard. This is the nuclear option of constitutional law. It dictates that if a law impacts the Second Amendment, the government cannot simply argue that the law saves lives or reduces crime statistics. Those arguments are now legally irrelevant in the face of the Constitution. For the government to uphold a restriction now, they must perform a forensic historical excavation. They must prove to a federal judge that a similar regulation existed at the time of the nation's founding, specifically around 1791 or 1868. This places the burden of proof entirely on the state. It is a complete reversal of the courtroom dynamic. Previously, you had to justify why you needed a weapon. Now, the state must justify why they have the authority to stop you, using historical analogs that simply do not exist for modern gun control measures. This mechanism effectively pre-programs the destruction of nearly every firearms restriction passed in the 20th and 21st centuries. The implications for 2026 are staggering. We are looking at a domino effect that threatens over 400 federal and state laws, from magazine capacity limits to assault weapon bans. These laws were built on the foundation of public interest, a foundation that the Supreme Court has now pulverized into dust. The government is currently scrambling to find historical precedents for banning AR-15 seconds in the 18th century, a task that is logically and historically impossible. This standard acts as a monolithic barrier against future legislation, forcing anti-gun politicians to confront the reality that their policy goals are fundamentally unconstitutional. Number 2, the vaporization of qualified immunity. For decades, the concept of qualified immunity has served as an impenetrable armor for law enforcement officers who trample on constitutional rights. It created a caste system where agents of the state could violate the Second Amendment with absolute impunity, shielded by the impossible requirement of clearly established precedent. This meant that unless a court had previously ruled on the exact specific set of facts in a prior case, the officer could not be sued. It was a rigged game designed to protect the enforcer at the expense of the citizen. That armor has now been shattered. The courts have pivoted to a stance where ignorance of the Second Amendment is no longer an excuse for law enforcement. If an officer confiscates your firearm without due process, conducts an illegal search, or arrests you for lawful carry, they are now staring down the barrel of personal liability. We are not talking about the department paying a settlement from taxpayer funds. We are talking about the officer's personal assets, their home, their pension, their savings being on the table in federal court. This fundamentally alters the psychology of enforcement on the street level. When an officer realizes that enforcing an unconstitutional order could result in their own financial annihilation, the dynamic shifts from compliance to hesitation. We are already seeing this in jurisdictions like Harris County, Texas, where deputies were forced to pay millions out of pocket. This creates a chilling effect on the enforcers themselves. The "I was just following orders" defense is eroding. In a survival scenario or a widespread confiscation attempt, this legal precedent serves as a massive deterrent, forcing individual agents to choose between their orders and their own livelihoods. Number 3. The annihilation of ex parte red flag seizures. The red flag phenomenon was perhaps the most dystopian acceleration of government overreach in the last decade, allowing for the seizure of property based on pre-crime predictive modeling and hearsay. The terrifying mechanism of these laws was their ex parte nature, meaning the hearing happened without you. A judge, a prosecutor, and an accuser would meet in a closed room, decide you were a danger, and authorize a tactical team to raid your home at 3 a.m., all before you had even been charged with a crime. It was the absolute antithesis of the American legal tradition. Recent rulings have struck at the heart of this Star Chamber tact. The judiciary has reaffirmed that the Second Amendment cannot be stripped away without the rigorous application of due process. This means notice, a hearing, the right to counsel, and the right to confront your accuser before rights are stripped, not weeks or months after your property has been seized. The courts have recognized that firearms ownership is not a privilege to be suspended on a whim, but a fundamental right that requires the highest threshold of legal adjudication to restrict. This change disrupts the swatting culture that red flag laws encouraged, where vindictive ex-partners or ideologically driven neighbors could weaponize the police against gun owners. By forcing the system to respect due process, the speed and secrecy that made red flag laws so dangerous are eliminated. The government can no longer operate in the shadows. They must bring their evidence into the light of a courtroom where it can be challenged, cross-examined, and destroyed. This effectively neuters the confiscation model that many states were hoping to expand leading up to 2026. Number 4. The mandatory federal data purge. We must address the silent, digital insurrection that has been taking place inside the ATF's National Tracing Center. While federal law explicitly forbids a national gun registry, the agency has been engaged in a massive workaround using industrial-scale optical character recognition technology. By collecting out-of-business records from defunct gun stores, they have amassed nearly 1 billion records. They were digitizing these paper documents, turning unsearchable boxes of files into a searchable, metadata-rich database that could track every transfer owner and serial number in seconds. The courts have not merely slapped the agency on the wrist, they have issued a demolition order. The mandate requires the certified, irreversible destruction of these digital indices within 90 days. This is a logistical and technological nightmare for the Bureau, but a massive victory for privacy. It forces the government to regress to 20th century technology, stripping them of the algorithmic power to map gun ownership across the continent. This destruction order is a direct attack on the surveillance state's infrastructure. This ruling exposes the secret flaw in the government's control grid, their reliance on digital centralization. By shattering this database, the courts have blinded the eye of Sauron. It ensures that in the event of a future confiscation effort, the government lacks the master list required to execute it efficiently. They are forced back into the dark, unable to press a button and generate a list of every AR-15 owner in a specific zip code. This restoration of informational asymmetry is critical for the preservation of liberty in the digital age. Number 5. The prohibition of financial dragnet surveillance. The war on gun owners has moved from the legislative floor to the digital banking sector, a strategy known as Operation Choke Point on steroids. Federal agencies, in collusion with major credit card processors and data brokers, established a surveillance grid based on merchant category codes, MCC. They were tracking purchases at gun stores, flagging transactions that looked suspicious, and creating a digital dossier on lawful gun owners without ever obtaining a warrant. It was a dragnet surveillance program designed to bypass the Fourth Amendment entirely. The judiciary has now drawn a hard line in the sand, ruling that the government cannot circumvent the Constitution by outsourcing tyranny to private corporations. Accessing the financial DNA of American citizens, their purchasing habits, their locations, their frequency of training, now requires a warrant based on probable cause of a specific crime. The mere exercise of a constitutional right cannot serve as the justification for monitoring that right. This restores the digital privacy of the gun owner, a concept that had been all but eroded over the last 20 years. This is critical because financial data is the ultimate intelligence tool. By cutting off the government's access to this stream, we disrupt their ability to build profiles on high-risk dissenters. It prevents the weaponization of the banking system, where your ability to buy bread could be threatened because you bought bulk ammunition. The court's intervention here prevents the construction of a social credit system based on Second Amendment compliance, forcing the government to investigate crimes rather than monitor lifestyles. Number 6. The administrative clock on permit bureaucracy. For decades, the May issue states places like New York, California, New Jersey used bureaucracy as a weapon. They knew they couldn't outright ban carry permits, so they simply stopped processing them. They created a pocket veto, where applications would sit in a dark room for 18 months, 2 years, or indefinitely. They burdened the applicant with proving good cause, a subjective standard that allowed police chiefs to deny permits to anyone who wasn't politically connected or a celebrity. It was corruption codified into administrative law. The Supreme Court's Bruin decision, and the subsequent lower court enforcement, has smashed this administrative blockade. The ruling mandates a shall-issue standard, stripping the state of its discretionary power. But more importantly, it imposes strict time limits, often 30 days, and caps fees. This transforms the permit process from a privilege granting ceremony into a rote administrative task. The state is no longer the gatekeeper of your safety, they are merely the clerk processing your paperwork. This shift has caused an explosion in carry permits in deep blue states, fundamentally altering the demographic landscape of gun ownership. By removing the artificial friction of time and cost, the courts have flooded the streets with lawful carriers. This herd immunity makes it exponentially harder for the state to roll back rights in the future. When millions of citizens are legally carrying, the political capital required to disarm them becomes insurmountable. The bureaucracy, once a wall, has been reduced to a speed bump. Number 7. The liberation of the ammunition supply chain. A firearm without ammunition is nothing more than an expensive club. Anti-gun strategists understood this perfectly, which is why they shifted their focus to choking the supply. States like California implemented background checks for every single box of ammo, creating a logistical bottleneck that resulted in massive denial rates due to database errors. Other states banned online shipments entirely, forcing buyers to pay extortionate prices at local brick-and-mortar stores. It was an economic siege designed to make shooting prohibitively difficult. The courts have recognized this for what it is: a direct infringement on the core right to keep and bear arms. By ruling that ammunition is inextricably linked to the firearm itself, they have extended full constitutional protection to the bullet. This eliminates the background check requirements for ammo and reopens the interstate commerce lanes for direct-to-door shipping. It treats ammunition as a consumer good rather than a controlled substance. The strategic impact of this cannot be overstated. It allows for the stockpiling of logistics without state interference. It decentralizes the supply chain, making it impossible for a state governor to simply turn off the flow of ammunition during a crisis. By reconnecting the shooter directly to the manufacturer, the market corrects itself, prices stabilize, and the ammo tax imposed by restrictive state laws evaporates. This ensures that the 2026 landscape will be one of abundance, not scarcity. Number 8. The end of zero-tolerance FFL persecution. Under the current administration, the ATF implemented a so-called zero-tolerance policy targeting federal firearms licensees. In practice, this policy functioned as a campaign of attrition, revoking licenses over trivial clerical mistakes, misspelled street names, transposed numbers, or minor formatting errors. The objective was not public safety, but reduction: eliminate gun dealers by weaponizing paperwork. By shutting down FFLs, the government could choke off the supply of new firearms without ever passing an outright ban. The legal backlash was swift and decisive. Courts clarified that a willful violation requires intentional wrongdoing, not ordinary human error. This distinction is critical. It protects lawful business owners who operate in good faith and prevents federal agencies from using bureaucratic technicalities as a tool of economic destruction. The ATF can no longer act as judge, jury, and executioner based solely on harmless paperwork discrepancies. It must now demonstrate criminal negligence or deliberate intent. This shift safeguards the survival of the national dealer network. Without FFLs, lawful firearm transfers cease to exist. By ending administrative warfare against small gun shops, the courts have preserved the logistical backbone of the Second Amendment. The ATF is now forced to direct its resources toward actual gun traffickers and violent criminals, rather than harassing lawful dealers over inconsequential clerical errors. Number 9. The restoration of the Fourth Amendment castle. The knock and talk has been a favorite tactic of federal agents for years. They would approach a home often based on purchase records of solvent traps or forced reset triggers and coerce the homeowner into a voluntary search. They relied on the citizen's fear and ignorance to bypass the warrant requirement. They treated the home of a gun owner as a regulated commercial space. blurring the lines between a business inspection and a private home invasion. The courts have forcefully reasserted the sanctity of the home, or the curtilage. The ruling clarifies that owning a firearm does not sign away your Fourth Amendment rights. Agents cannot enter your property, inspect your collection, or demand to see your serial numbers without a warrant signed by a judge based on probable cause. The administrative search exception does not apply to the private citizen. This creates a hard perimeter around your property. It stops the fishing expeditions. It means that if the government wants to know what is in your safe, they have to prove to a judge that you are a criminal first. This restores the balance of power, forcing the state to respect the physical sovereignty of the citizen. It effectively ends the intimidation tactics used to confiscate accessories and force compliance through fear. Number 10. The Federal Interstate Travel Shield. For decades, driving through states like New Jersey, Maryland, or New York with a firearm was a game of Russian roulette. Even if you were following the Firearm Owners Protection Act, local police and prosecutors would ignore federal law, arrest you, and let the courts sort it out years later. It was a state-sanctioned trap designed to imprison out-of-state travelers and generate revenue. The safe passage provision was treated as a suggestion, not a law. The recent reinforcement of these protections has turned the interstate highway system back into federal territory. The courts have clarified that if your possession is legal at your point of origin and your point of destination, the states in between cannot touch you. This includes the necessary stops for food, fuel, and rest. The burden has shifted. Police departments that arrest lawful travelers now face the liability we discussed in Law Number 2. This opens up the country. It allows for the free movement of arms and owners without the terror of navigating a patchwork of hostile jurisdictions. It affirms that your rights do not evaporate simply because you crossed an invisible line on a map. This is the unification of the Second Amendment across state lines, a critical step in dismantling the regional tyranny that has plagued the Northeast and West Coast for generations. Do not let this victory lull you into a false sense of security. The 2026 crisis is still approaching. The legislative branch will attempt to rewrite these laws, to find loopholes in the court's logic, and to invent new ways to restrict your rights. They will move from public safety arguments to public health emergencies. They will try to pack the courts to overturn these precedents. We have won a major battle, perhaps the most significant in our lifetime, but the war for the soul of this nation's Constitution is eternal. You are now armed with the knowledge of your new protections. Use them. Spread them. Refuse to be intimidated by a government that relies on your ignorance to maintain its power. Stay vigilant.